Hello and welcome to In Depth. I'm Tina Jha. The Law Commission of India is a non-statutory executive body constituted by the government for a fixed tenure of 3 years. The panel, that has mainly legal and judicial experts, acts as an advisory body to the Ministry of Law and Justice. The Law Commission has a pre-independence origin. However, the first panel in independent India came into being in the year 1955. And since then, we've had 21 law commissions, each of them making important contributions towards the progressive development and codification of laws in the country. The 22nd Law Commission was approved on the 19th of February this year by the Union Cabinet, chaired by Prime Minister Narendra Modi. On this edition of In Depth, we'll talk about the 22nd Law Commission of India. Who all will it consist of, its role and functions, and also its significance. We'll also look at some important recommendations made by the law commissions over the years. A law commission is constituted when the central government passes a resolution to this effect after the expiry of the previous one. Once the resolution is passed and the President gives assent to it, the government appoints the chairperson of the new commission. Usually, the Law Commission is headed by a retired judge of the Supreme Court or a former Chief Justice of a High Court. The other members in the panel are also legal and judicial experts. In this report, let's tell you all about the 22nd Law Commission that has been approved by the Union Cabinet. The Law Commission is a non-statutory body that advises the government on complex legal issues. On Wednesday, the Union Cabinet approved the constitution of the 22nd Law Commission. Following this, the Law Ministry will now notify the new panel that will have a term of 3 years. The panel will have a full-time chairperson and 4 full-time members, including a member secretary. Law and legislative secretaries in the Law Ministry will be the ex officio members of the Commission. It will also have not more than 5 part-time members. A retired Supreme Court judge or Chief Justice of a High Court will head the Commission. According to an official statement, the Commission shall, on a reference made to it by the central government or suo motu, undertake research in law and review of existing laws in India for making reforms and enacting new legislation. It shall also undertake studies and research for bringing reforms in the justice delivery systems to eliminate delay in procedures, speedy disposal of cases, reduction in cost of litigation, etc. The Law Commission shall also identify laws that are no longer needed or relevant and can be immediately repealed. It will further examine existing laws in the light of directive principles of state policy and suggest ways to improve and reform them. It will also suggest legislations necessary to implement the directive principles and to attain the objectives set out in the preamble of the Constitution. Moreover, the Commission will also consider and convey to the government its views on any subject relating to law and judicial administration that may be specifically referred to it by the government through the Ministry of Law and Justice. It shall also consider the request for providing research to any foreign country as may be referred to it by the government. The Law Commission shall also take all necessary measures to harness law and legal process in the service of the poor. It shall revise central acts of general importance so as to simplify and remove anomalies, ambiguities and iniquities. Before finalizing its recommendations, the Commission shall consult the nodal ministry or department and other stakeholders necessary for the purpose.
The term of the 21st Law Commission expired in August, and therefore there was a need to appoint a new commission. But it is very important to know the recommendation of the 21st Law Commission, which was headed by Justice B.S. Chauhan, who is a retired judge of the Supreme Court. And one of the important recommendations was to repeal a lot of obsolete laws and to also review all those laws so that they do not remain on the statute book. And therefore, in this 3,000 laws till now have been already removed from the statute book.
The tenure of the 21st Law Commission headed by former Supreme Court Judge Justice B.S. Chauhan, came to an end in August 2018. The 21st Law Commission had submitted reports and working papers on key issues such as simultaneous polls to the Lok Sabha and state assemblies and a uniform civil code. In 2015, a proposal was mooted to make the law panel into a permanent body either through an act of parliament or an executive order such as a resolution of the Union Cabinet. The move was, however, shelved after the Prime Minister's office felt that the present system should continue. Earlier in 2010 as well, the then UPA government had prepared a draft cabinet note to give statutory status to the Law Commission, and the Law Ministry had mooted to bring the Law Commission of India Bill 2010. But the idea was again shelved. Since 1955, when the first Law Commission was constituted post-independence, the panel has made important contributions towards progressive development and codification of law in the country. So far, the Law Commission has submitted 277 reports. With inputs from Vipul Agarwal, Bureau Report, Rajya Sabha TV.
Sometimes making laws alone is not sufficient. Its implementation also needs to be checked to understand if it's actually beneficial for the society or if there are any flaws that need to be corrected, which is what the Law Commission of India does. It also ensures that peace prevails in the society and justice is being delivered to people. The tenure of each Law Commission is 3 years. In our next report, let's tell you about the functions and role of the Law Commission of India.
The Law Commission of India is an executive body established by an order of the Government of India. Its major function is to work for legal reforms. It is established for a fixed tenure and works as an advisory body to the Ministry of Law and Justice. The Law Commission comprises legal experts assigned by the government to take good care of the laws and create maximum peace, security and justice in the society. Its regular staff consists of about a dozen research personnel of different ranks and varied experiences. A small group of secretarial staff looks after the administration side of the Commission's operations. The Law Commission, on a reference made to it by the central government or suo motu, undertakes research in law and a review of existing laws in India for making reforms therein and enacting new legislations. The Law Commission ensures that the widest section of people are consulted in formulating proposals for law reforms. Once data or information is assembled, the Commission's staff evaluates them and organizes the information for appropriate introduction in the report. Once a report and a summary are finalized, the Commission may decide to prepare a draft amendment or a new bill that may be appended to its report. Thereafter, the final report is forwarded to the government. The Ministry of Law reviews the Law Commission's report with the consultation of the concerned administrative ministries, which then submit it in Parliament.
See, the primary role of the Law Commission is to advise the central government on complex legal issues and legal and judicial reforms in the country, and also to suggest the elimination of obsolete laws.
The other functions of the Law Commission include identification of laws that are no longer relevant and recommending for the repeal of obsolete and unnecessary enactments, considering requests for providing research to any foreign countries as may be referred to it by the government, examine the existing laws with the view of promoting gender equality and suggesting amendments thereto. Despite being an ad hoc body, the Law Commission has been key to law reform in India. It plays a crucial role in ensuring public interest and helps in the formulation of strong public policies. While on the one hand, it acts as an advisory body, on the other it criticizes government policies that do not benefit the public. In case of any defect in any public policy, it points out the defective part of the policy and suggests some ways to correct it. The recommendations of the Commission are not binding on the government. They may be accepted or rejected. Also, the liberty of taking up matters suo motu acts as a beneficial factor in cases where there is no one to raise objection on some defective laws. The Supreme Court too has recognized the recommendations made by the Commission. In many cases, the Supreme Court has accepted and followed the recommendations made by the Commission. The main purpose of the Law Commission is to help the government to shape just public policies and ensure justice is delivered. Therefore, it is the responsibility of both the government and the Commission to work in close coordination because in the end, it is the public interest that matters. Bureau Report, Rajya Sabha TV.
Time for a short break here on the program, but when we return, we'll talk about some important recommendations made by the Law Commissions over the years. Do stay with us.
Watch The Big Picture with me, Vishal Dahiya, at 9:30 p.m. on Rajya Sabha TV.
In a major step towards granting women the right to serve in the army on equal terms with men, the Supreme Court granted women the right to permanent commission and the right to command.
This was a battle for all of these women who wanted to do something for the nation, but they were being restrained or prevented.
Nobody has ever questioned the capacity, the capability and the zeal. I'm simply saying the necessity. It's not required. There are many mountains to conquer.
Chair is a chair, the rank is a rank. Men do not give salutation to a woman or a man. They give their salutation to the rank that the woman or a man is wearing on the uniform.
देखिए विशेष मेरे साथ आज शाम 7:30 बजे सिर्फ राज्यसभा टीवी पर।
The Qutub complex in Mehrauli is not just a place that houses the eponymous Minar, but also a landmark that represents once ruler's desire to build an even taller structure that could have overshadowed even the Qutub Minar. Alauddin Khilji, who called himself Sikandar-e-Sani or the Second Alexander, had commissioned the construction of Alai Minar. Though the work had begun on the structure opposite Qutub, due to death of Khilji, the construction was abandoned, never to be taken up by any other ruler. Even in its incomplete state, the magnitude of Alai Minar is awe-inspiring. It stands a lot wider at the base than Qutub Minar, and though just one story exists, it stands 80 feet, one-third the size of older counterpart. Probably the only unfinished monument in Delhi is a marvel to behold, for nothing induces more wonder than a strong first step with an illusion of how great things could have been.
देखिए मेरे साथ देश देशांतर रात 8:30 सिर्फ राज्यसभा टीवी पर।
सूत्या महलड़ा गोखड़ा रे सूत्यो नचीत संसार बिजो कर्ण। अभी भी ना कॉस्ट्यूम डिजाइनिंग इट्स अ क्रूशियल पार्ट ऑफ द फिल्म मेकिंग, लेकिन मुझे लगता है कि अभी भी उतना आगे नहीं बढ़ाया जा रहा जितना कि बाकी चीज़ों को किया जाता है।
पिताजी क्या करते थे, जो आदमी राइट लेफ्ट नहीं देखता सीधा जाता है बहुत तरक्की करता है।
जब मैं अपने असिस्टेंट्स को देखती हूँ, अपने स्पॉट बॉयज़ को देखती हूँ, अपने रनर्स को देखती हूँ, जिस तरह की परिस्थितियाँ में वो लोग काम करते हैं, वो मुझे लगता है अभी क्रेडिट नहीं मिल रहा। नमस्कार, मैं हूँ डॉली आलूवालिया। मुझसे मिलिए प्रोग्राम गुफ्तगू में,
सिर्फ राज्यसभा टीवी पर।
Welcome back. You're watching In Depth. Let's now talk about the formation of the Law Commission. Demands for a law commission to examine central acts and recommending lines on which they should be amended, revised or consolidated were made right after independence. Although even in the pre-independence era, the British government had formed such law panels. But the first Law Commission of Independent India was formed in the year 1955.
Law reform is a continuing process and has happened off and on over the last 300 years in India. In ancient India, when religious and customary laws were the driving force, the reforms process was not institutionalized. However, beginning in the third decade of the 19th century, law commissions were constituted by the government from time to time. They were empowered to recommend legislative reforms with a view to clarify, consolidate and codify particular branches of law where the government felt the necessity for it. The first such commission was established in 1834 under the chairmanship of Lord T.B. Macaulay, which recommended the codification of the Penal Code, the Criminal Procedure Code and a few other matters. Thereafter, the second, third and fourth law commissions were constituted in 1853, 1861 and 1879, which during a span of 50 years contributed a great deal to enrich the Indian statute book with a large variety of legislations on the pattern of the then prevailing English laws adapted to Indian conditions. The Indian Code of Civil Procedure, the Indian Contract Act, the Indian Evidence Act, the Transfer of Property Act, etc. are products of the labour of the first four law commissions.
The first law commission was formed under the British Raj in 1834, and thereafter under independent India it was formed in 1955. M.C. Setalwad was its first chairman, and thereafter this is the 22nd commission, and the term of the commission is 3 years. It is an ad hoc body, not a permanent body, and it submits its report to the central government. It is an advisory commission. Its recommendations are not binding on the government.
On July 26, 1954, the All India Congress Committee resolved that a law commission should be appointed to revise the laws promulgated nearly a century ago by the Law Commission of Macaulay and to advise on current legislation from time to time. The Constitution of India, with its fundamental rights and directive principles of state policy, gave a new direction to law reform geared to the needs of a democratic legal order in a plural society. Though the Constitution stipulated the continuation of pre-Constitution laws under Article 372 till they are amended or repealed, there had been demands in Parliament and outside for establishing a central law commission to recommend revision and updating of the inherited laws to serve the changing needs of the country. The Government of India reacted favourably and established the first Law Commission of Independent India in 1955 with the then Attorney General of India M.C. Setalwad as its chairman. The terms of reference to the commission were, firstly, to review the system of judicial administration in all its aspects and suggest ways and means for improving it and making it speedy and less expensive. Secondly, to examine the central acts of general application and importance and recommend the line on which they should be amended, revised, consolidated or otherwise brought up to date. Since 1955, 21 law commissions have been established. Each of these commissions have been chaired by a prominent legal personality of the country and has made a significant contribution to the legal diaspora of India. Bureau Report, Rajya Sabha TV.
And let's now take a look at some important recommendations that the Law Commission has made over the years in diverse fields, from electoral reforms to DNA profiling and the Indian Evidence Act.
Various law commissions have made significant recommendations. They include the 244th report submitted by the 20th Law Commission of India, looked at electoral disqualifications, important reforms that it suggested related to safeguards that ensure prevention of misuse of provisions, and in case of any lack of redressal, it advised remedies. Offences that involve a maximum punishment of 5 years or above were incorporated within this provision. It said that if charges were filed less than a year from the date of scrutiny of nominations for an election, it will not result in disqualification. charge of disqualification will not be removed unless acquitted by the court or a term of 6 years, whichever is earlier. If the charges are framed against sitting MP or MLA, then the case must be resolved as soon as possible, which is within 1 year. In report number 255 on electoral reforms submitted in March 2015, the 20th Law Commission suggested some methods to make the system more effective. These far-reaching measures touched diverse topics like election finance, regulation of political parties and inner-party democracy, proportional representation, anti-defection law in India, strengthening the office of the Election Commission of India, paid news and political advertisements, opinion polls, compulsory voting, election petitions, nota and the right to reject, the right to recall, restrictions on the government-sponsored advertisements, restriction on the number of seats from which a candidate may contest, and rule governing independent candidates. The 16th Law Commission in 2003 submitted a report related to the review of the Indian Evidence Act 1872. Some recommendations include suggestions to include revenue courts and tribunals within the definition of the code. The Commission observed that evidence produced by the computer should be treated similar to other records, though preference must be given to its authenticity. The Commission also recommended that specifically mentioning DNA as a piece of evidence under the Act was not necessary.
Various important recommendations have been made by various commissions over the period of time. So, say example, social and economic offences and various benches of a high court within a state, then Benami transactions, insolvency laws, and you should child protection and women protection laws and protection of parents also. The other examples are witness protection and compensation in the case of accidents and various other welfare measures, and also various measures have been recommended by the Law Commission to remove delays in the judicial system.
The 20th Law Commission presented the 262nd report on death penalty, in which it made a recommendation to abolish the death penalty. The Commission observed that the death penalty should be abolished in all cases except in cases of waging war and terror-related cases. It was observed that the death penalty provides deterrence of criminal activities not more than that provided by life imprisonment. The Commission believed that the imposition of death penalty in rarest of rare cases doesn't ensure that there will be no miscarriage of justice. The 21st Law Commission prepared the 271st report on human DNA profiling, a draft bill for the use and regulation of DNA-based technology. The measures it suggested were setting up a DNA profiling board, rules and regulations that the board will have to lay down for police officers and investigating officers to deal with the DNA cases. On a DNA data bank, the Commission proposed that the central government set up a national DNA data bank and regional DNA data bank. It also sought uniform standards of working in the laboratories where the work related to DNA profiling was carried out. On the anti-defection law, the Law Commission suggested changes in the 10th schedule of the Indian Constitution to provide power to the President or the Governor on the issue of disqualification on the ground of defection. The President and the Governor will have to act on the advice of the Election Commission of India. With inputs from Vipul Agarwal, Bureau Report, Rajya Sabha TV.
And that's it from us on this edition of In Depth. In case you missed the television broadcast of our program, you can also watch it online on YouTube and Twitter. And you can also get back to us with your feedback and suggestions. Thank you for your time.